You know, there are things in life we fiercely guard. Secrets, confidential thoughts, plans you wouldn't share with just anyone.
Hmm.
And in the intense world of legal disputes, the conversations you have with your lawyer are perhaps the most fiercely protected secrets of all.
Absolutely. It's this thing called client legal privilege, or sometimes legal professional privilege. It's fundamental.
It's like a legal shield, isn't it?
Mm.
Designed so you can be completely open and honest with your lawyer, knowing that what you share won't be, used against you or dragged out
Uh-huh.
later in court.
That's the idea. It's not just about being convenient. It's seen as absolutely essential for the proper administration of justice.
How so?
Well, look, if clients can't be totally upfront with their lawyers because they're scared it might get disclosed later, then the lawyer can't give proper, accurate advice. And if that happens, the client's rights can't really be protected properly. So, yeah, privilege is a really powerful tool.
A powerful tool, definitely. But like any powerful tool, it has limits, right? And figuring out where those limits are, where you draw the line around what's genuinely protected, well, that can lead to massive fights.
Especially when parties are, fighting tooth and nail to get hold of documents during a legal battle.
Exactly. And that specific tension, that's really what brings us to the heart of this deep dive today. Because while everyone sort of agrees that confidential chats with your lawyer can be privileged,
Hmm.
the huge fight, the core problem this case had to solve, it all came down to the purpose.
The purpose behind the communication or maybe the document that was created.
Yeah. What kind of purpose actually qualifies for this protection? Does seeking legal advice have to be the only reason, the absolute sole reason you create a document?
Or is it maybe enough if seeking legal advice is just the main reason, the most important one, the dominant reason?
Sole versus dominant. It sounds like such a small difference in wording, doesn't it?
Yeah. It does, but as this case we're looking at showed so clearly, that tiny difference had massive practical consequences. It led to, well, confusion, lots of frustration, and eventually a fundamental shift in the law itself.
And the case that finally tackled this head on, the one that really dramatically redefined this crucial principle in Australia, that's Esso, Australia Resources Limited v. Commissioner of Taxation.
Esso versus the tax office, that's the one.
Now, I know what you might be thinking. Esso versus the tax office. Sounds maybe like the driest possible topic, right? A corporate tax dispute?
Doesn't exactly scream drama, does it?
Not initially.
Yeah.
But trust us, if you peel back the layers of this case, what you find is actually a really high-stakes legal drama. It played out over years, involved a massive fight over mountains of documents. It was essentially a fight about secrets.
Yeah, it was a clash over access to information, definitely. But it was also this really profound debate about how the law itself should adapt, how it should evolve when faced with, new business realities and conflicting legal rules.
So our mission today is to unpack this really fascinating, incredibly important case. We're going to trace its journey step by step from that initial tax dispute in the federal court all the way up the ladder to the highest court in Australia, the High Court.
And along the way, we'll meet the key players. You've got the determined parties, Esso and the commissioner. You've got the insightful judges at each level. And of course, the formidable legal teams who crafted all the arguments.
We'll see how the different courts wrestled with what looked like contradictory laws. And ultimately, we'll reveal how the High Court's final, really landmark decision didn't just settle this specific tax fight between Esso and the commissioner.
No, it went much further. It fundamentally changed a core principle of Australian law for, well, pretty much everyone, every individual, every company, every organization.
Okay, let's get into it then. Before we dive right into Esso's specific battle with the tax commissioner, we probably need to set the scene a bit.
Yeah.
What was the legal landscape actually like for client legal privilege in Australia before this case really blew up?
Right. Good place to start. So at common law, that's the law developed by judges through court decisions over time. Client legal privilege was already really well established. It was seen as a fundamental right.
And it works as an exception to the general rule, doesn't it? The rule that usually says you have to disclose everything relevant in a court case.
Exactly. Think of it like this. Normally, in litigation, you've got to show your hand, reveal all the relevant information to the other side. Privilege is one of the very few, quite carefully defined situations where you don't have to do that.
And it's an old idea.
Oh, very old. Its roots go back centuries in English law. It's tied to the idea that for a legal advisor to give effective help, they need the client to tell them everything, absolutely everything, without being scared it's going to come back to bite them.
So, a long-standing principle. But how was it specifically defined and applied here in Australia before Esso came along? What was the actual test everyone had to follow?
Ah, okay. That brings us to a really crucial High Court decision from way back in 1976. The case was called Grant v. Downs. And for decades, Grant v. Downs was basically the Bible on legal privilege in Australia. It established what became known everywhere as the sole purpose test.
The sole purpose test, just the name itself sounds pretty strict. What did that actually mean in practice for, clients and lawyers trying to communicate?
It was definitely strict. Under the rule that came out of Grant v. Downs, for any communication or any document to be protected by privilege, the only reason, the absolute sole purpose for creating it had to be either seeking legal advice, giving legal advice, or for use in court proceedings that were happening or that you expected might happen.
The only reason.
The only reason. If that document had any other purpose at all, even if it was a really significant purpose that was kind of tangled up with the legal one, the privilege was lost, gone.
Wow. Okay, let me just make sure I'm getting this straight because this feels really key. Imagine, right, you're an executive in a company. Something happens. Maybe there's an accident on site, or maybe you're planning some really complex deal. You obviously need legal advice on the risks, the potential liability.
Sure, standard stuff.
But you also need to write a report about it.
Yeah.
For internal reasons, maybe, I don't know, to improve safety procedures based on the accident, or perhaps to brief the board on the business side of the deal. Under Grant v. Downs, if that report you wrote served both purposes, getting legal advice and briefing the board or improving safety, it might not be privileged. Because getting legal advice wasn't the only reason it was created.
That's precisely it. That was the potentially harsh reality of the sole purpose test from Grant v. Downs.
Yeah.
In that actual case, Grant v. Downs, it involved reports written after someone died in a psychiatric hospital. And those reports were prepared for multiple reasons. Checking up on staff conduct, looking at the hospital's systems and procedures to see if they needed changing, and getting legal advice about potential lawsuits down the track. Because getting legal advice wasn't the sole purpose, the High Court said, nope, not privileged.
You can see how that would cause problems pretty quickly, especially, I guess, in modern companies or big organizations where documents often wear multiple hats, serve multiple functions.
Exactly. It sounded and often was incredibly difficult to apply cleanly in practice. Almost artificial, as you said. How often does a document in the real world genuinely have only one single purpose driving its creation?
Yeah, not often, I'd imagine.
Well, that's certainly what a lot of critics thought, and the whole situation got even more complicated, believe it or not, when Parliament decided to step into the picture.
Parliament got involved. How?
In 1995, the Commonwealth Parliament passed the Evidence Act, and this big piece of legislation, it introduced a different test for legal privilege. But, and this is the crucial bit, its application was specifically limited.
Okay, a different test in the Act. What was this new test?
The Act brought in what's called the dominant purpose test. You find it in sections 118 and 119 of the Act. Basically, those sections said that evidence couldn't be used in court if it revealed a confidential communication or a confidential document that was made or prepared for the dominant purpose of getting legal advice or preparing for legal proceedings.
Dominant purpose. Okay, that immediately sounds a bit more flexible, maybe more forgiving. Not the only purpose, but the ruling one, the primary one, the most important one.
Exactly. The dominant purpose test is generally seen as a more practical standard. It kind of acknowledges the reality that, yeah, a document can have multiple purposes, but it asks you to figure out which one was the main driver, which purpose was the most influential reason for bringing that document into existence.
And is that used elsewhere?
Oh, yeah. It's the test that's favored in many other common law countries. Think the UK, Canada, New Zealand. So it looked like Parliament was maybe moving towards a more modern, perhaps more workable approach.
Okay, right. So Parliament brings in this more flexible, dominant purpose test. But you said its application was limited. How was it limited?
Yes, and this limitation, this is the absolute key to understanding the weird situation, the anomaly, as the courts called it, that the Esso case eventually had to fix. The Australian Law Reform Commission, the ALRC, they did a lot of the groundwork review leading up to the Act.
Okay.
And they specifically noted in their report that the privilege provisions in the Evidence Act, those sections 118 to 126, were deliberately written to apply only to the process of adducing evidence in the courtroom. That means presenting evidence at the trial itself.
Only at the trial, not before.
Exactly. The ALRC specifically pointed out this meant the Act's new dominant purpose test did not apply to all the stuff that happens before you actually get into the courtroom. Things like pretrial discovery, where parties exchanged lists of documents and the inspection of those documents.
Whoa, okay, hold on. This is where my head starts to spin a bit.
Yeah.
So after 1995, let's say you had a court case in the federal court, which uses this new Evidence Act. You could have a document
Yep.
that was privileged, meaning you couldn't show it to the judge at the trial because its dominant purpose was legal advice.
Correct, under the Evidence Act test.
But that exact same document, if the other side asked to see it during the discovery phase, months or even years before the trial started, it might not be privileged because its sole purpose wasn't legal advice, according to the old common law rule from Grant v. Downs.
You got it exactly. That was the absolutely bizarre and frankly deeply problematic situation that existed. You had two different tests for the same fundamental legal principle, client legal privilege, potentially applying to the very same piece of paper at different stages of the very same court case.
Depending on whether you were handing over lists of documents or actually arguing in front of the judge.
Precisely. And don't forget, the common law sole purpose test from Grant v. Downs still applied across the board in state courts that hadn't passed their own similar evidence acts. It was a real patchwork.
That sounds not just confusing, but potentially really unfair. You could be forced to hand over documents before the trial that you could legitimately stop the other side from using against you at the trial.
That's exactly the point. It was, as one judge, Justice McClellan, put it in an earlier case called Telstra v. Australis Media Holdings. He described the situation as anomalous, conducive to confusion and disorder, and verging on the absurd.
Verging on the absurd. Strong words from a judge.
Yeah, it created huge uncertainty. It became a really common point of argument, slowing down litigation. And this messy kind of two-tiered legal landscape with the strict old common law sole purpose rule crashing up against Parliament's newer dominant purpose test for courtroom evidence. That was the world that the Esso case landed in. It was, you could say, a conflict just waiting for a test case.
Right. And setting the stage for this conflict, we obviously have our key players, the individuals, the organizations who are going to fight this battle all the way through the courts. Let's meet the cast of characters in this legal drama.
Okay, so first, you have the parties who were locked in the actual dispute. On one side, the company that was challenging the tax assessments, the one who eventually appealed to the High Court, was Esso Australia Resources Limited.
Esso, the oil and gas giant.
That's them. They were the party who had claimed privilege over literally hundreds of documents, and they'd claimed it using the more relaxed dominant purpose test. They desperately needed that test to be declared the correct one for the discovery phase, so they could keep all those documents confidential away from the tax office's eyes.
Okay. And who was on the other side?
The respondent, the one defending the tax assessments and wanting to get access to Esso's documents, was the Commissioner of Taxation of the Commonwealth of Australia, the tax office.
Right.
Their interest, naturally, was the complete opposite. They argued forcefully for the stricter sole purpose test from Grant v. Downs. If that test applied, then Esso's privilege claims over many of those multi-purpose documents would probably fail.
And the commissioner would get to see them.
Exactly, giving the commissioner potentially valuable information for the underlying tax dispute. So you had this direct clash of interests purely driven by these two different legal tests for privilege.
Okay, so we've got the corporate heavyweight Esso versus the government tax authority, the commissioner. Now, what about the legal minds who had to try and untangle this mess of the judges? Let's walk through who presided at each stage.
Okay, we start at the very beginning, the first instance hearing in the federal court. The specific judge who heard the arguments on just the privilege question, remember it's separated out, was the Honorable Justice Michael Leader Foster.
Justice Foster.
Justice Foster, yes. As a federal court judge at that time, he was bound by the existing law, particularly the precedents set by the High Court. His job really was to apply the law as it stood.
Which meant applying Grant v. Downs.
Which meant applying Grant v. Downs and its sole purpose test to the discovery phase. And his judgment reflects that. He carefully applied the precedent, even though he sort of acknowledged the awkwardness of the whole situation.
He had to follow the rules, even if they seemed, well, absurd. So Esso obviously appealed that decision. It went up to the full bench of the federal court. Who heard the case there?
Right. The appeal in the full federal court was heard by quite a substantial bench, 5 judges, actually, which signals how important the court thought this question was.
5 judges. Who were they?
The panel was made up of the Honorable Chief Justice Michael Eric John Black, the Honorable Justice Brian Allen Beaumont, the Honorable Justice Ross Allen Sundberg, the Honorable Justice Ronald Merkel, and the Honorable Justice Raymond Finkelstein.
That's a senior lineup.
Very much so. Chief Justice Black, leading the court, was known for his interest in how common law interacts with and adapts to legislation. Justice Beaumont was a very experienced senior judge. Justices Sundberg, Merkel, and Finkelstein were relatively newer appointments back then, but already highly regarded legal minds. This was the bench that had to grapple directly with that tension between the old common law rule and the new Evidence Act.
Did they look at other recent cases when they were thinking about this?
They did, very much so. They heavily referenced and, in fact, essentially adopted the core reasoning from another recent full federal court decision. That case was called Adelaide Steamship Co. Ltd v. Spalvins.
Adelaide Steamship. Okay.
Now, the judges who actually sat on the Adelaide Steamship case, Justices Oni, Kiefel, and Finn, they weren't on the Esso panel themselves, but their analysis in Adelaide Steamship about how the common law should sort of respond to the Evidence Act, that was absolutely central to the full court's decision in Esso. So you could say Justices Olney, Kiefel, and Finn played a really significant, albeit indirect, role in the Esso outcome at that stage.
That's fascinating. So the thinking was kind of evolving across different full court benches around the same time. And then finally, the case reaches the absolute summit, the High Court of Australia.
The final stop. The High Court bench that heard the Esso appeal consisted of Chief Justice Gleeson and Justices Gowdron, Gummow, McHugh, Kirby, and Callanan. Justice Hayne didn't participate in this one.
The highest court in the land.
This group, obviously, represented the highest legal authority in Australia. They had the power to settle the law definitively for the whole country, and crucially, if they thought it was necessary, they could overturn previous High Court decisions, including Grant v. Downs.
And was there a mix of judicial philosophies on that bench?
Oh, yes. You had a range of judicial approaches represented. Justice Kirby, for instance, was quite well known for his views on the need for the common law to develop and adapt. On the other hand, you had Justice McHugh, whose very detailed analysis in the Esso judgments shows just how deeply the court considered the practical and theoretical arguments for and against each test. They were the ultimate arbiters of this really fundamental legal question.
A real powerhouse of legal minds. Okay, so we have the judges. Now, who are the lawyers, the advocates, bringing the arguments of these judges? Who are the barristers and solicitors fighting it out for Esso and the commissioner?
As you'd expect for a case like this, these were absolutely top-tier legal teams on both sides. At the very first stage, before Justice Foster in the federal court, the records suggest who was likely involved, based on who appeared later. For Esso, who were represented by the law firm Clayton Utz.
Clayton Utz, big firm.
Big firm. It looks like their counsel were B.W. Shaw QC and J.W. DeWin QC, both Queen's Counsel senior barristers.
Okay. And for the commissioner?
For the Commissioner of Taxation, represented by the Australian government solicitor, the team appears to have been led by G.A.A. Nettle QC, another prominent silk appearing with C.M. Maxwell and M.M. Gordon as junior counsel. So experienced teams right from the start.
Did those same teams stick with it when the case went up to the full federal court?
Yes, largely. The legal teams remained pretty consistent for that full federal court appeal. Shaw QC and DeWin QC continued to represent Esso, arguing hard for the dominant purpose test, still instructed by Clayton Utz.
And the commissioner.
And Nettle QC, Maxwell, and Gordon continued for the commissioner, defending the sole purpose test as the right one for discovery, instructed by the Australian government solicitor. It makes sense keeping continuity with counsel who already knew the case inside out.
Right. But what about the final battle, the appeal to the High Court? Did we see the same faces again, or did the teams change for the ultimate showdown?
This is where we see a significant change, which often happens when cases reach the High Court. Parties often bring in barristers who specialize in appearing before that specific court.
Makes sense. So who led for Esso in the High Court?
For Esso, the team was led by Mr. D.F. Jackson QC, David Jackson QC. A hugely respected silk, particularly known for his expertise in commercial law and high court appeals. He was joined by D.J. Chauvin QC and N.J. Young QC, also prominent senior counsel in commercial and appellate work. They were presumably still instructed by Clayton Utz. Bringing in someone like Jackson QC really highlights how much weight Esso put on this final appeal.
A real specialist for the top court. And what about the commissioner's team in the High Court? Did they also change leadership?
They did. The commissioner's case was argued by Mr. D.S. Grieve QC. Now, significantly, he was the Solicitor General for New South Wales at the time.
The Solicitor General. That's a big deal.
It is. The involvement of a Solicitor General, a very senior legal officer representing the government, really underscores the public importance the government saw in this case. It wasn't just about this one tax dispute anymore. It was about a fundamental principle of law. Grieve QC was supported by G.T. Pagone QC and T.F.W. Hughes QC, presumably instructed by the Australian government solicitor. Again, a lineup of highly regarded senior counsel.
Wow. So both sides brought out the absolute biggest legal guns for the High Court fight.
They really did. It truly was a clash of legal titans, reflecting the complexity and the fundamental importance of the question being decided.
Okay, that's a serious roster of legal talent, highlighting just how high the stakes were. So, we've got the core issue, these two different tests for privilege causing chaos. We've got the players, Esso, the commissioner, the judges, the top lawyers. Let's trace the actual procedural journey now. Step by step, how did this case actually move through the courts?
Right, the journey. Well, the starting point wasn't actually the privilege issue itself. It began, as many of these things do, with a disagreement over tax. Pretty much. The core dispute was between Esso and the Commissioner of Taxation over Esso's income tax assessments for several years back in the late 1980s and early 1990s. The specific technical issue was about whether interest that Esso had paid on a deal involving acquiring units in something called the Delhi Australia Fund was actually a legitimate tax deduction.
Okay, so a fairly standard, if complex, corporate tax dispute initially. When did it move from being just a disagreement or negotiation into actual formal litigation?
That happened in 1996. The dispute couldn't be resolved, so Esso took the formal step of commencing proceedings in the Federal Court of Australia. They filed appeals against the amended tax assessments that the commissioner had issued. That's the standard legal path you take if you want to challenge a tax assessment you disagree with.
Got it. So the appeal is filed in the federal court. What's a typical next step in big commercial litigation like this before you get anywhere near a trial?
Well, that leads you straight into the discovery phase, and that's where our privilege story really kicks off. In October 1996, the federal court made standard orders requiring discovery and all the related appeals Esso had filed.
Discovery. That's where each side has to list the relevant documents they have.
Exactly. Discovery is the process where each party has to prepare a list of all the documents they hold that are relevant to the issues in the case. And then, subject to any valid claims for privilege, they generally have to allow the other side to inspect those documents. It's all about transparency, making sure everyone knows the relevant evidence, preventing trial by ambush. The federal court rules at the time laid out exactly how this process was supposed to work.
And this discovery process is precisely where the privilege problem became a concrete issue for Esso.
Precisely. Fast forward to June 1997. Esso, as part of meeting its discovery obligations, filed its formal affidavit listing all its relevant documents. Now, in this list, Esso claimed legal professional privilege over a really significant number of documents. The High Court judgment mentions 577 documents.
577 documents. That's a lot.
It is. And crucially, when Esso made this claim, they explicitly stated in their affidavit that these documents were privileged because their dominant purpose was getting legal advice or for use in the litigation. They deliberately used the dominant purpose test from the Evidence Act, not the old sole purpose test from Grant v. Downs.
So Esso basically threw down the gauntlet. They put the issue squarely before the court by claiming privilege using the test they believed was the correct one. How did the commissioner react to that?
Predictably, the commissioner immediately challenged Esso's claims. They filed formal applications notices of motion asking the court to order Esso to let them inspect all those documents that Esso had claimed were privileged based on the dominant purpose test.
And the commissioner's argument was?
Their argument was crystal clear. For the purposes of discovery, the binding law was still the High Court's 1976 decision in Grant v. Downs, which required the sole purpose test. This created a direct, unavoidable clash. The court couldn't proceed with the main tax case until it figured out which privilege test was actually the right one to apply during discovery.
Right. So instead of diving into the arguments about interest deductions on the Delhi Australia Fund, the court first had to sort out this fundamental legal question about privilege. How did they decide to handle that?
Well, the judge, at first instance, Justice Foster, decided, and both Esso and the commissioner agreed to this approach to separate this legal question out from the main tax case. He ordered that two specific questions of law should be decided first as a preliminary issue before anyone even started arguing about the tax assessments themselves.
A separate hearing just on the privilege test. Smart move. What were those specific questions he had to answer?
Okay, the first question, question 1A, was the absolute core of the whole saga, it asked. When it comes to documents listed during discovery, is the correct test for claiming legal professional privilege the sole purpose test from Grant v. Downs, or is it the dominant purpose test found in the Evidence Act? That was the big one.
The billion-dollar question, almost literally given the context, what was the second question?
The second question, 1B, was kind of related. It asked, did the federal court's own procedural rules give the judge the power to let Esso withhold documents based on meeting the dominant purpose test, even if the sole purpose test was technically the correct common law rule for discovery? Could the rules provide a workaround, essentially?
Okay, these questions cut right to the heart of that legal anomaly we talked about. What was Justice Foster's ruling? Which test did he say applied?
Justice Foster handed down his judgment in late 1997. He approached it, as we said, as a judge bound by the High Court's precedent. So on question 1A, he found that, yes, the sole purpose test from Grant v. Downs was, at that time, the correct common law test for privilege over documents discovered in the federal court.
He stuck with the old rule for discovery?
He did. He acknowledged that the Evidence Act used a different test, the dominant purpose test for evidence actually presented at trial. But he concluded that the Act's scope was clearly limited by Parliament and didn't override or change the common law rule that applied before trial during discovery.
And what about the second question about the court rules?
On question 1B, he answered that in the negative. He found that the court rules didn't give him any power to basically ignore or override the applicable common law privilege test. So his ruling meant that for Esso's 577 documents to be considered privileged during discovery, they had to meet that very strict sole purpose test. And as a consequence, he ordered Esso to pay the commissioner's legal costs for this separate hearing.
So round one goes to the commissioner and the stricter sole purpose test. Esso understandably wasn't going to leave it there, I assume. What was the next step in the procedural journey?
No, Esso wasn't giving up. They immediately sought and were granted permission to appeal Justice Foster's decision to the full bench of the federal court.
Back to that panel of 5 judges we met earlier.
Exactly. The appeal was heard by Chief Justice Black and Justices Beaumont, Sundberg, Merkel, and Finkelstein. Esso's counsel, Shaw QC and DeWin QC, argued really vigorously that applying different tests at different stages was illogical, impractical, and created absurd results. They pushed the idea that the common law itself should evolve, especially in courts like the federal court that operated under the Evidence Act, to embrace the dominant purpose test for everything, including discovery.
And the commissioner's response.
The commissioner's team, led again by Nettle QC, defended Justice Foster's ruling. They argued that Parliament's intention in the Evidence Act was perfectly clear. Dominant purpose applied only when evidence was adduced at trial. For everything else, including discovery, the High Court's ruling in Grant v. Downs remained the binding common law. End of story.
This sounds exactly like the core debate we identified earlier. How does the judge-made common law react when Parliament passes a law on a related topic, but deliberately limits the scope of that law? What did the full federal court decide?
In December 1998, the full federal court delivered its judgment. And it was a very significant move. They effectively overturned Justice Foster's decision in substance. They found that, yes, the dominant purpose test did apply to discovery in the federal court.
Whoa. Okay, so they went against Justice Foster. But how did they justify that, given Foster J. was just applying what seemed like binding high court precedent from Grant v. Downs?
Well, their reasoning was quite complex, and it actually became a major point of argument later in the High Court appeal, drawing very heavily on that earlier Adelaide steamship decision we mentioned.
Right.
The majority of the full court judges concluded something quite novel. They said that while the Evidence Act didn't directly amend or change the common law rule for discovery, the very introduction of the act had fundamentally changed the legal landscape or setting in those jurisdictions where the act applied, like the federal court.
Change the landscape. What does that mean?
They argued that the common law principle of client legal privilege, which had historically been linked to courtroom proceedings but then got extended out to discovery, had been, quote, derivatively modified by the arrival of the Evidence Act.
Derivatively modified. That sounds creative.
It was. Essentially, they believed the common law had to sort of bend or adapt itself to align with the statutory tests that applied at trial in order to avoid that absurd anomaly of having two different tests. One of the judges, Justice Merkel, reached the same final conclusion that dominant purpose applied, but he got there via a slightly different path. arguing for a very broad interpretation of the Evidence Act itself, saying it implicitly intended its test to cover related processes like discovery.
So regardless of the exact reasoning, the full court said dominant purpose wins for discovery too.
Yes. The outcome was they allowed Esso's appeal, they set aside Justice Foster's orders, and significantly, they ordered the Commissioner of Taxation to pay Esso's legal costs, not just for the appeal, but also for the original hearing before Justice Foster.
Okay, so the full federal court lands on dominant purpose, but uses this pretty novel derivative modification argument, suggesting the common law in that specific court had kind of shifted automatically because Parliament passed the Evidence Act. That sounds like an intermediate appeal court taking a really bold step regarding a high court precedent, doesn't it?
It was definitely a bold step, and it didn't sit well at all with the Commissioner of Taxation. This is precisely why the case didn't end there. The Commissioner appealed again, this time taking the fight to the very highest court, the High Court of Australia.
Okay, the final round. What was the Commissioner's argument to the High Court?
The Commissioner argued, basically, that the full federal court had got it wrong. They argued that only the High Court itself has the power to overturn a previous High Court decision, like Grant v. Downs. They said the full court's idea of derivative modification was legally incorrect. And they maintained that the Evidence Act was crystal clear in its limited scope. It applied to adducing evidence, not discovery. So the central question for the 7 justices of the High Court was the full federal court correct in applying the dominant purpose test to discovery? And if they were correct in the result, what was the proper legal basis for it? Was it derivative modification? Was it statutory interpretation? Or perhaps was it time for the High Court itself to directly reconsider the common law rule from Grant v. Downs?
And this led to the final High Court hearing, the highest level of legal argument, leading eventually to the landmark decision that changed everything.
Exactly. The High Court heard extensive, detailed arguments from David Jackson QC's team for Esso, pushing hard for the dominant purpose test to be recognized universally. And they heard from David Grieve, QC's team for the Commissioner, defending the sole purpose test for discovery and arguing the full court had overstepped. The justices considered everything: the long history of privilege, the precise reasoning in Grant v. Downs, the wording and purpose of the Evidence Act, those ALRC reports that had highlighted the problem, the full federal court's complex reasoning, and also how other similar common law countries dealt with the issue.
And when did they deliver the final word?
On the 22nd of December, 1999, almost exactly a year after the full federal court decision, and just over 2 years after Justice Foster's initial ruling on those separate questions, the High Court delivered its powerful, unanimous judgment.
Unanimous. Okay. What was the verdict? Did they agree with the full federal court that the dominant purpose test applied?
Yes, they did agree with the final outcome reached by the full federal court. They agreed that the dominant purpose test was the correct test to apply to Esso's documents, including for the purposes of discovery.
Ah, so Esso won on the key point.
Esso won on the key point, yes. However, and this is absolutely crucial, the High Court explicitly rejected the full federal court's reasoning for getting there. They particularly threw out the whole idea of derivative modification.
So they said the full federal court reached the right destination, but they took completely the wrong road to get there.
That's a perfect way to put it. The High Court was very firm. They stated clearly that an intermediate court of appeal, like the full federal court, simply does not have the authority to decide that a High Court precedent like Grant v. Downs should no longer be followed or has somehow been implicitly changed, even if Parliament has passed related legislation. Overruling or significantly departing from a High Court decision, that's a job only the High Court itself can do.
Okay. So if they rejected the full court's reasoning, and they were technically still bound by their own previous decision in Grant v. Downs, which set the sole purpose test, how did the High Court justify applying the dominant purpose test in this case?
This is the truly significant, the really game-changing part of their judgment. The High Court decided that given all the circumstances, the confusion, the anomaly, the legislative changes, the developments elsewhere, the time was right for them, the High Court, to formally revisit and reconsider their own earlier decision in Grant v. Downs.
You decided to reopen the old case, basically.
Exactly. They listed several key factors that influenced this decision. They noted that Grant v. Downs itself had actually departed from some earlier understandings of privilege. They pointed out that the fundamental policy choice between a sole purpose test and a dominant purpose test hadn't really been fully argued or explored before the court back in 1976 when Grant was decided. They also looked overseas and saw that other major common law jurisdictions, like the UK, had since clearly adopted the dominant purpose test. And very importantly, they considered the fact that the Commonwealth Parliament and the New South Wales Parliament had both deliberately chosen the dominant purpose test when they enacted their Evidence Acts.
Ah, okay. So the fact that Parliament chose dominant purpose for courtroom evidence didn't automatically change the common law for discovery, which is what the full court had kind of argued. But it served as a powerful signal, a piece of context for the High Court itself, suggesting that maybe the common law itself needed a rethink.
Precisely. The High Court used those legislative developments, and the ALRC reports highlighting the practical problems as important context and forming their own reevaluation of the fundamental common law principle. It wasn't derivative modification, it was the High Court taking note of the legislative trend as it reconsidered the common law.
And after that reevaluation, what did they conclude about the best test?
After carefully weighing everything, the High Court concluded that the dominant purpose test is, in fact, the test that strikes the best, most appropriate balance between the two competing public interests that privilege law tries to serve.
Which are?
On the one hand, you have the public interest in encouraging full and frank disclosure between clients and their lawyers so people can get proper legal advice and access justice. That's the argument for privilege. On the other hand, you have the public interest in ensuring that courts have access to all relevant information needed to find the truth in litigation. That's the argument against privilege being too broad. The High Court decided that dominant purpose struck a better balance between these two goals than the old sole purpose test did.
So the High Court didn't just decide the Esso case. They actually went further and declared that the common law test for client legal privilege for the whole of Australia was now and should be the dominant purpose test, effectively overturning their own decision in Grant v. Downs after more than 20 years.
That is exactly what they did. They settled the matter decisively and authoritatively. They went back and formally answered those original questions that had been put to Justice Foster way back at the start.
How do they answer them now?
They answered question 1A by stating, the correct test for claiming legal professional privilege, including for discovery, is the dominant purpose test, which is now declared to be the common law test across Australia. And for question 1B about the court rules, they said that question basically didn't need a separate answer anymore because the applicable common law test was now dominant purpose anyway.
And the outcome of the appeal itself?
Technically, they allowed the commissioner's appeal because they disagreed with the full federal court's reasoning. But they upheld the result of the full federal court because they agreed that dominant purpose did apply. And importantly, acknowledging that Esso had ultimately succeeded in establishing the correct legal test, the High Court ordered the commissioner to pay Esso's legal costs from the first instance hearing and the full federal court appeal.
So the underlying tax case could finally proceed.
Yes. The substantive tax appeal between Esso and the commissioner could now finally get back on track, with everyone knowing that discovery and indeed all privilege claims would be governed by the dominant purpose test.
Wow. What an incredible journey, all driven by this seemingly technical clash between two different purpose tests and ultimately resolving with the highest court in the land stepping in to fundamentally redefine the common law itself. Let's dig just a little deeper now into the absolute core of that conflict. Why were these two tests so different in practice? And what were the main arguments used to defend each one?
Yeah, we've touched on it, but it's really worth reinforcing just how different they were, maybe with some concrete examples. The fundamental difference, as we've said, between sole purpose and dominant purpose is how they treat documents or communications that were created for more than one reason.
Right.
Under Grant v. Downs, the sole purpose test was, just like the name says, incredibly narrow. If a document had any purpose other than the strictly legal ones seeking or giving advice or litigation, then privilege was probably lost.
Like those reports about the psychiatric hospital death and the Grant v. Downs case itself. Getting legal advice was definitely a purpose, maybe even an important one, but it wasn't the sole purpose.
Exactly. Or think about another famous case, this one from England, called Waugh v. British Railways Board, which really influenced the debate here. After a bad train collision, an internal report was prepared. It was created for two main reasons. First, standard procedure to figure out what went wrong. For safety reasons, for internal review. Second, Because they knew litigation was likely, it was also prepared to help get legal advice. Under a strict sole purpose test, like the one Australia had under Grant v. Downs, that crucial internal report would almost certainly not have been privileged.
Because it had that significant non-legal purpose, the safety review alongside the legal purpose.
Precisely. The safety purpose killed the privilege claim, even if the legal purpose was also very important.
Okay, so sole purpose really casts a very small, very tight net for privilege protection. What about dominant purpose? How would that test change things for those kinds of examples?
Well, under the dominant purpose test, which is now the common law standard in Australia thanks to the High Court in Esso, those kinds of documents would likely be privileged, provided that the legal purpose was the ruling reason, the primary driver, the most influential reason for creating them in the first place.
So for that train collision report,
For the train collision report, if you could show that the main reason, the dominant driver, for preparing it right then and there was the urgent need to understand the potential legal liability and get ready for the expected lawsuits, then the fact that the report would also be used later to improve safety procedures wouldn't necessarily defeat the privilege claim. It's about figuring out the preponderance of purpose. Which one tipped the scales?
that definitely sounds much more realistic, much closer to how documents probably get created in big, complex organizations today. What were the main arguments used by those who defended the old sole purpose test? Why do they argue against moving to dominant purpose?
Well, those arguing to stick with sole purpose, like the Commissioner of Taxation in this case, and also Justice McHugh in his very detailed analysis in the High Court judgment, they emphasized what they saw as its strengths. They argued it was simpler, clearer, more of a bright line rule, easier for people to apply in practice, they thought, and less open to subjective arguments about what was dominant versus merely significant.
So certainty and clarity were key arguments.
Certainty, clarity, and also a desire to keep privilege contained. They worried that moving to a dominant purpose test would lead to privilege expanding too far. They felt it might allow too many multi-purpose documents, especially internal corporate documents, to be shielded from disclosure, which would hinder the court's ability to get to the truth. McHugh, in particular, voiced concerns that the dominant purpose test, while maybe seeming fairer for individuals, could end up being overly advantageous for large corporations and powerful government bodies, making it much harder for others to access potentially crucial internal documents. He also raised practical worries about the difficulty and the cost of litigating subjective purpose, forcing courts to spend time trying to figure out the exact state of mind of whoever created the document.
Okay, so the argument for sole purpose was basically it's clearer, it keeps privilege narrow, and that ultimately better serves the public interest in getting information out. What about the arguments for dominant purpose, the ones that Esso pushed and the High Court majority ultimately accepted?
The proponents of dominant purpose argued really strongly that it just better reflected the reality of modern life, especially modern communication and document creation within complex organizations. They argued the sole purpose test was, frankly, extraordinarily narrow and often led to unfair results, defeating privilege even when the legal purpose was clearly very important. This, they said, undermined the whole policy reason for having privilege in the first place, encouraging people to be candid with their lawyers.
And they pointed to what was happening elsewhere.
Absolutely. They pointed to the legislative trend here in Australia Parliament choosing dominant purpose for the Evidence Act. And they highlighted the approach taken in other major common law countries like England, Canada, and New Zealand, all of which had moved away from a strict sole purpose test precisely because it was seen as impractical and often unjust.
So the argument was it's more practical, it aligns with international best practice, and it strikes a better balance between encouraging candor and allowing disclosure in our complex world.
Yes. And crucially, they argued it avoided that absurd situation of having different tests apply at different stages of the same case or in different courts dealing with related matters. The High Court majority, in the end, found these arguments persuasive.
And can you just recap the High Court's specific reasoning again for choosing dominant purpose as the common law test, the test that applies everywhere now, not just under the Evidence Act?
Sure. Their reasoning was really multi-layered. As we discussed, they first decided it was appropriate for them to reconsider Grant v. Downs. They gave reasons for that. Grant itself had changed the law, the policy choice wasn't fully argued back then, other countries had gone a different way since, and our own parliaments had chosen dominant purpose for evidence law. Then, having decided to reconsider, they looked at the two tests on their merits and concluded that the dominant purpose test itself actually provides a better balance between those competing public interests we talked about, facilitating legal advice, versus ensuring access to information for justice.
Even though applying it might be difficult sometimes.
They acknowledged that applying either test could be difficult in practice, but they suggested that trying to figure out the single sole purpose could sometimes be just as artificial, maybe even more so, than figuring out which purpose was dominant. And they used the legislative trend, the Evidence Acts, not as something that automatically changed the common law, like the full court thought, but as important context, important background information that informed their own decision to develop the common law in that direction. It showed them which way the wind was blowing, legally and societally.
So the High Court, as the ultimate authority on the common law, looked at the whole picture, the history, the problems, the trends here and overseas, and decided it was time to update the common law standard itself to one that was more practical and widely accepted.
That's exactly right. They used the opportunity provided by the Esso appeal to authoritatively declare that the dominant purpose test was now the common law test for client legal privilege throughout Australia. It applies everywhere unless Parliament specifically passes a law to create a different rule for a particular situation, which generally hasn't happened. The trend since Esso has very much been towards this uniform dominant purpose standard.
Okay. And that brings us neatly to the lasting impact, the legacy of Esso v. FCT. How did this single case fundamentally change the way law is practiced in Australia for everyone?
Well, the most obvious impact, the big headline change, is that fundamental shift in the test itself. The sole purpose test, which had been the law for over 20 years since Grant v. Downs, was officially replaced by the dominant purpose test as the standard for common law legal professional privilege.
And this immediately fixed that confusing anomaly, that absurd situation we started with.
Absolutely. This one decision brought much-needed uniformity and clarity. Now, the same test dominant purpose applies whether you're talking about documents during discovery or inspecting documents that someone has been forced to produce under a subpoena or arguing about whether a piece of evidence can be used against you at trial.
So no more two different tests for the same document.
Exactly. It applies consistently across federal courts and all the state and territory courts that apply the common law. That chaotic situation where different tests could apply depending on which stage of the proceedings you were at, or even which court you were in, was largely eliminated.
So for lawyers, for clients, for judges trying to manage cases, there's now just one consistent standard they need to apply when they're assessing privilege claims.
Yes, that major source of confusion and argument was resolved. And this had really significant practical implications across the board.
Like what?
Well, for lawyers and their clients, particularly perhaps, within large corporations and government agencies, documents that previously would have definitely lost privilege under the super strict sole purpose rule, because they clearly had significant non-legal purposes alongside a legal one, well, now those documents had a much better chance of being protected.
As long as the legal purpose was the dominant one.
As long as you could argue convincingly that the legal purpose was the dominant one, the main driver, then the privilege would hold.
This must have been a huge relief, particularly for those big organizations that routinely create documents serving multiple functions: board papers, internal reports, emails.
Oh, it was hugely significant. Think about things like internal investigation reports after an incident, or risk assessment memos, or board papers discussing a potential acquisition that cover both the commercial strategy and the potential legal hurdles, or even just emails where people are discussing business plans but also asking for legal input. Under Grant v. Downs, trying to make sure those complex, multi-purpose documents met the sole purpose test was a constant headache. Lawyers often had to give clients very specific instructions, like, make sure you create a separate document only for the purpose of seeking my advice.
Which isn't always practical.
Not at all. Esso provided a much more realistic framework. Now, it didn't suddenly mean that any document that happens to mention legal advice is automatically privileged. Not at all. You still have to prove that the legal purpose was dominant. But if obtaining legal advice or preparing for litigation really was the primary driver for creating that document, it was now protected.
So it made claiming privilege more feasible, more achievable for certain types of very common organizational documents.
Yes. And interestingly, it probably also encouraged a more disciplined approach within organizations over time. Because while dominant purpose is less strict than sole purpose, you still have to be able to prove dominance if challenged. So companies and government bodies likely became even more careful about how they documented the purpose behind creating sensitive reports or seeking advice. You often see things now like explicit statements in meeting minutes or cover sheets saying, the dominant purpose of this report discussion is to obtain legal advice from our lawyers, precisely to help substantiate a privilege claim later if needed.
Right, creating the evidence to support the claim later. And how did this change affect litigation itself, beyond just that initial discovery fight?
Well, it certainly streamlined the process in one key respect by removing what had become a very frequent source of preliminary disputes. Parties no longer had to waste time and money arguing about whether a document that was clearly privileged under the Evidence Act for trial purposes was nevertheless discoverable beforehand under the common law sole purpose test. That specific fight disappeared.
So fewer procedural skirmishes.
Fewer skirmishes over that particular issue, yes. Of course, disputes about privilege still happen all the time, but now they tend to focus on the real substance. Was the legal purpose truly dominant in this specific situation? Or was some other commercial or administrative purpose actually the main driver? It shifted the battleground away from navigating the minefield of two different tests towards debating the facts of the specific purpose.
And finally, stepping back, what does this whole Esso saga tell us about the bigger picture, about how the common law evolves in Australia?
I think Esso v. FCT is just a classic textbook example of the common law's inherent capacity for evolution and the absolutely critical role the High Court plays in that process. Yeah. It demonstrates very clearly that common law principles, even fundamental ones like privilege, are not set in stone. They're not static.
They can change.
They can, and they do adapt over time. They respond to changing societal needs, to new practical realities in business or technology, to developments in legislative policy, even when Parliament's actions are limited in scope, and also to trends they see happening in other similar legal systems overseas. The High Court's willingness in Esso to revisit and ultimately overturn its own clear precedent from Grant v. Downs because it was convinced that a change was necessary to better serve the overall public interest. That's a really powerful illustration of this adaptive capacity.
It shows the conversation between Parliament and the courts too, doesn't it?
Absolutely. It shows that dialogue. Parliament's legislative choices, like adopting the dominant purpose test in the Evidence Act, even for a limited purpose, clearly informed and arguably spurred the High Court to reconsider and develop the common law itself in the same direction.
So it really is a testament to the dynamic nature of Australian law, shaped by these hard-fought battles between determined litigants, argued by brilliant lawyers, and ultimately guided by the High Court, acting as the final steward of the common law.
Exactly. And it just shows how something that might appear incredibly technical on the surface, like the precise definition of the word purpose in a legal test, can actually be the focal point for a profound reshaping of a fundamental legal principle that genuinely affects everyone interacting with the legal system.
It really is a fantastic illustration of the legal system in action. So for someone listening to this, why does understanding this particular case matter to you? Why is a tax dispute from the 1990s about legal privilege still relevant today?
Well, I think it matters because it directly underpins a principle that protects your confidential communications when you seek legal advice. And that applies whether you're dealing with personal matters, maybe buying a house or writing a will, or unfortunately getting into a dispute with a neighbor, or whether you're involved in running a business. The confidence you have, that you should have, that what you tell your lawyer in confidence will actually stay confidential. That confidence is shaped by the boundaries of client legal privilege. And Esso v. FCT was the case that fundamentally redefined those boundaries in Australia.
So it ensures you can get that full, frank, honest legal help you need without constantly looking over your shoulder worrying that your candid discussions might somehow be exposed later.
That's the core idea. It's directly relevant to anyone who might ever need to consult a lawyer. And beyond that practical relevance, I think it's also just a fascinating window into how our law actually works.
How so?
For anyone who's curious about how law evolves, how it adapts, this case is just a perfect case study. It shows that interplay between judge-made law, the common law, and laws made by Parliament, statute. It shows the power of precedent, but also how precedent can be overturned. It shows the confusion that can arise when different legal rules seem to clash. And crucially, it shows how the highest court in the system steps in to provide clarity, resolve conflict, and ultimately shape the future direction of the law. It proves that even seemingly dry, abstract legal concepts are actually the battlegrounds for intense, real-world conflicts with very significant consequences.
What a journey indeed. From a disagreement over tax assessments to a fundamental battle over the definition of legal privilege, ultimately changing a core principle of Australian law.
That's right. The battle of the purposes, you could call it, finally reached its resolution. Dominant purpose is now the established common law test right across Australia, and that's thanks directly to the High Court's decisive ruling in Esso v. FCT.
And that brings us, as always, to a final thought to leave you with. While SOVFCT did unify the test for privilege, bringing much-needed clarity to what was a very confusing situation, it didn't, and probably couldn't, eliminate the underlying tension that privilege law always grapples with. The law is still constantly trying to balance two really important public interests: the interest in getting to the truth through full disclosure in litigation, versus the interest in protecting confidential legal advice so that people can effectively access justice.
That tension is always there.
Always there. So here's the thought. As technology continues its relentless march forward, creating completely new ways for us to communicate, new ways to create and store documents, things unimaginable back in 1999, and as our legal processes continue to adapt to this digital world, how will our courts continue to navigate and balance these two essential and sometimes conflicting public interests? How will the dominant purpose test hold up in the age of instant messages, collaborative documents, and AI-assisted legal work? Something to consider.